Welcome to Bekaert Industrial Manufacturing and Consumer Goods podcast series. We aim to explore this dynamic world and discuss the operating challenges facing manufacturers and offer new ideas and solutions. Join us as we uncover growth strategies and enhance after-tax cash flow in an ever-evolving industrial and consumer goods landscape. Hello, and welcome to another episode of our Industrial Manufacturing and Consumer Goods podcast series. I'm your host, Luis Reyes, the Industrial Manufacturing and Consumer Goods leader at Bekaert. Today, I'm joined with Nelson Yates, our International Tax leader. Nelson, welcome to the podcast.
Thank you.
Great to have you here.
Oh, great to be here. Looking forward to the conversation today.
I think everyone who's listening is as well. Tariffs continue to be a moving target for manufacturers. So I'm looking forward to digging into what's happening right now and what manufacturers should be thinking about as they plan ahead. First, let's talk about what manufacturers need to know. Can you give us a snapshot as to where we are within the tariff landscape today? Refunds, trade investigations, court rulings, and what's going on?
Absolutely. There's a lot that is going on, right? No question. Our clients are well or acutely aware of everything going on, especially in the manufacturing or industrial space. There are still the Section 232 tariffs that are out there. We're not going to really touch on those today. Those haven't changed. There are opportunities if you work with trade advisors or trade consultants, trade counsel to try to mitigate some of those. But we're going to put those off to the side. So today, let's talk about the IEEPA tariffs and really the refunds related to those. Let's talk about the Section 122 temporary tariffs that got put into place. And then, as you rightfully pointed out, we have Section 301 trade investigations, which very likely are going to result in tariffs. So where are we at with the IEEPA tariffs? We know, right, I think everybody knows that's been following any of this, even at a very high level, that the United States Supreme Court found that the IEEPA tariffs were unconstitutional. That was back on February 20th. Since then, what has happened? Well, while they were found unconstitutional within the Supreme Court, there was no sort of talk about refunds or how refunds should go. Atmos filtration, which was a case before, or is a case before the U.S. Court of International Trade, is where the actual refund process is starting to get ironed out. As of March 4th, that is where Judge Eaton of the Court of International Trade came out and said, okay, hey, look, let's get the refund process started. CBP, Customs, Border and Protection came out and said, hey, this is great, but we're looking at 330,000 importers of records. We need some time to figure out how to do this. They asked for a 45-day extension. We're still within that 45-day window. What's been happening during those 45 days? Well, the courts asked the CBP to provide regular updates, which they have done. And the primary focus of those updates have been on modifying the ACE system, which is, the portal that importers of records and brokers have access to that show the entries and the tariffs that have been calculated, as well as the status, liquidated, unliquidated, et cetera. They've added a new functionality, or they're in the process of adding a new functionality. That's called the CAPE, which is Consolidated Administration and Processing of Entries. So this CAPE functionality has 4 components. They are making significant progress. Every one of these components is over halfway done. And what that new component or functionality is going to allow to do is for those importer of records to make filings or CAPE declarations seeking refunds. The court has modified its order from March 4th several times, and what was a big blank or open space were those entries that had been liquidated and could possibly be finalized by the time that the CAPE functionality was up and running and refunds could actually be sought. So this didn't gonna get unnoticed by the judge himself or by legal counsel and people in the marketplace. As recently as about a week and a half ago, 2 weeks ago, the thought was, hey, look, you need to be talking to counsel to preserve your rights, because if you have a entry that gets liquidated and finalized before you could file for a refund through the CAPE functionality of the ACE portal, you might be kind of in a tough spot. There's no real clear path as to what to do. The most recent order that's dealt with this was March 27th. Judge Eaton came out and said, okay, look, we're going to have all unliquidated entries be refunded. We're going to have all liquidated entries that haven't been finalized be reliquidated without the tariffs. And those that have been liquidated and finalized, if there are any, or as they happen, we're going to make those get reliquidated without the tariffs. So now you have the Court of International Trade tackling this once a kind of gray area and say, no, 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 kind of regardless of the status of liquidation to finalize, or I should say unliquidated all the way up to liquidated and finalized, it's part of this refund process. On March 31st, the CBP came out, they filed their declaration, as they're required by the court every couple weeks or every week or so, and said, hey, look, here's the update. And what they pointed to is they said, that's great. We will update the CAPE system to take into consideration this new sort of layer, i.e. the liquidated and finalized to their extent there are any, although there will be more coming really in June and on. And we can talk about that, what that means if we want to. But we gotta have like some phases. We already were going to have phases to this CAPE portal's functionality or the functionality of this CAPE system. So phase one is probably not going to deal with those. Phase one is going to be limited. It's going to allow you to file CAPE declarations, i.e. claims for refunds, for a significant number of the entries which IEEPA tariffs were imposed upon. They're estimating it to be about 63% of all entries that are eligible for refunds of the IEEPA tariffs are going to be able to be filed as part of phase one, which is a win for most people. And that's going to be for all unliquidated entries and for liquidated entries that are still within what's called a 90-day period for voluntary reliquidation. And that can get a little technical and looks to some of the statute as what that means. But it basically means, hey, look, the calculations of the duties have been set, i.e., so it's been liquidated, but it's within 90 days of that point in time. Those are all going to be part of phase one. And again, that's going to be about 63% of those entries that are eligible for refunds in total. There's going to be a phase two, I don't know, maybe a phase three, who knows, where some of these other things that are not addressed in phase one will be able to be submitted through the CAPE or use the CAPE functionality as part of the ACE portal. So that's where we're at on IEEPA refunds. We still have Section 122 temporary tariffs. They were announced on February 20th as soon as the Supreme Court ruled that the IEEPA tariffs were unconstitutional. The administration came out, put Section 122 temporary tariffs in place. They became effective on February 24th, I believe, and they expire or like organically expire on July 24th. So you'd think that, okay, they're going to go away, but not to leave a stone unturned, there was a lawsuit filed against those on, I believe, March 5th within the Court of International Trade as well, U.S. Court of International Trade, same court that the Atmos filtration as it relates to the IEEPA tariff refund process is in, different judge. So that is underway as we speak. Right now, as I understand it, based on the filings that have been made, the states that filed in the court, state of Oregon, state of California, several other states, they have asked for a motion for summary judgment or, in the alternative, an injunction to pause the imposition of the Section 122 tariffs. The administration has responded, and that's sitting before the court. Now, I don't know what kind of timing it'll take for the court to come out and have a ruling of any sort. I think it goes unsaid that, however this case actually comes out, it's very likely someone will appeal. The losing party probably will appeal. So that's our 122s, and then we've sort of got our 301s, which are trade investigations. Those are underway. There are a ton of jurisdictions or economies, as they say, that are currently being investigated. There's two components. March 11th, there was the trade investigations open for basically excess manufacturing capacity, right? All about foreign capacity being above and beyond demand, so they are able to sell into the U.S. and sort of drive down internal capacity, manufacturing capacity, or possibly just snuff it out in its entirety because they're able to they're dumping it at lower prices. That was instituted on March 11th. On March 12th, there was one about failure to address imports that had been created with the assistance of forced labor. Again, really a pricing concern, right? Because if you're using forced labor, the argument is you're able to manufacture at an unfair advantage. Where those sit right now, public comment period is coming to a close, I believe, on April 15th. And then there's going to be hearings held starting on May 5th. The thought, although nobody's really out there saying this is exactly how it's going to happen, but the thought is, hey, look, we had the IEEPA tariffs. They got found unconstitutional. They put in the Section 122s. Those expire by law on July 24th, assuming they aren't found unconstitutional or an injunction isn't put against them, but they expire or set to expire on July 24th. Maybe the 301s are supposed to have the conclusion and findings well in advance, so the administration's in a place to put tariffs, right, on certain economies, on certain goods as of July 24th, if not in advance. So that way you don't really have a pause in the tariffs, right? The 122s roll off. The results of the 301s allow new tariffs to be instituted that come on board as of, July 24, when the 122s come off. So there's sort of this building block, I think, with the intent to get back to where we were underneath the IEEPA tariff regime. So that's a quick snapshot. I know that was probably like 8 minutes of me rambling, but that's sort of where we're at. And I'm happy to double click on any of those.
Yeah, and I think the whole purpose of this is, there is a lot going on, right? So that leads to essentially the next question, right? Everyone's looking for practical advice. On that note, what advice do you have for manufacturers that have paid IEEPA tariffs and are wondering about refunds?
Yeah, it's a great question. I have several conversations a week, either with colleagues within Cherry Bekaert or with their client base, right? So there's really two ways to think about it. If you are an importer of record, what should you be doing, right? That means you have access to the ACE portal. So first thing you should do is make sure you have access to your ACE portal, right? Log in, make sure you're up to date on all of that. Go in there, fill out your ACH refund information. The Treasury, and that includes this refund process here, right? Nobody's mailing paper checks for the billions or more of dollars that are coming out of this. So you need to have effectively your direct deposit information set up. So when a refund is available and you apply for it and it gets all processed, that they're actually going to be able to just push it to your bank account and you're not sitting there going, oh, I'm eligible, I filed, they have my money, but they can't send it to me. And I think as of March 26th, something like only 76% of the importer of records have done so. So if you haven't done that yet, that's like step one. Step two is take a look at your entries within that ACE portal to understand where are you at. What do you have that's liquidated? What do you have that's unliquidated? What do you have that's either been finalized or on the verge of getting to be finalized? And then you can sort of categorize like, okay, these are probably phase ones. I'm going to be able to put a refund request or CAPE declaration in for all my unliquidateds and the liquidateds that have happened within 80 days of or have been liquidated within 80 days as of April 20th, right? Because that is the intended timing for the first phase one functionality of the CAPE program. So you should be able to file phase one refund requests on April 20th. So those are like two basic building blocks to do if you're an importer of record. Understand your data, make sure your bank account information is put into the system. If you aren't an importer of record and you have borne the cost, if you will, of the IEEPA tariffs because they have been passed downstream to you by your either, who you're buying from, and maybe they're the importer of record, or maybe you're even further downstream. I would assume at some point in time when they said, hey, look, we're paying tariffs now, you have to help shoulder that burden, there was some amount of documentation around that, whether that was a modification or an addendum to your original legal agreement or some secondary kind of agreement related to that pricing pushed down to you, you'd want to kind of get your hands around what that is, right? What do I have that says, yes, I agreed to this? And is there anything that talks about refunds or price adjustments if those tariff percentages changed or a refund was available? So understand sort of your legal footing there. And then same thing, get your documentation order. Obviously, you're not going to have access to ACE, but you should understand like, okay, look, here are the invoices that I've paid. Here's the breakout. They gave me line items of saying what was the markup for the given IEEPA tariff. Okay, great. I've paid this much. And then have a conversation with that vendor, right? Like, hey, look, are you pursuing IEEPA refunds? If so, what are how do you plan on distributing those back? Because you've pushed those down to, people such as myself. If you have in-house counsel, I would recommend talking with in-house counsel, right, as part of that. If you don't have in-house counsel, and maybe even if you do you want to have a conversation with external trade counsel or contract counsel, really? Maybe you do. So I think the situation is a little bit more precarious for those of you that have been bearing the cost of the IEEPA tariffs, but aren't importers of records. You'd like to think everybody's going to do right, in the name of relationship preservation and good business practices, but I'm sure somewhere there will be some unsavory characters that don't want to share the refunds that they pursue. And so you should know what your legal rights are in those instances, and that would be legal counsels who you need to be talking to about that.
Gotcha. So you kind of already touched on this. So putting aside refunds, what sort of best practices can manufacturers undertake, knowing that it's likely tariffs will continue to be here in some shape or form?
Yeah, so the president just released his budget, and I believe for the course of the next 10 years, every year the administration is projecting tariff income or receipts from tariffs to far outstrip those from corporate tax. So tariffs, at least under this administration, the idea is they are here to stay in some form. And we all know, right, regardless of who's in office, once government officials get the taste of certain types of revenue, it's really hard to break them of that type of revenue, regardless of their political leanings and maybe their posturing on trade. So tariffs very likely are part of the future. To what extent remains unknown at this stage, at least post this administration remains unknown. What do you do? Well, I think some of the best practices we've talked about of how do you think about the IEEPA refunds is what you would institute from a going forward perspective, meaning what sort of data integrity do I have? What processes am I scrambling to do right now to try to think about how to get a refund that if you were to tell me, hey, look, we may want to do this again for the 122s if they get found unconstitutional, or in the future, what are the things that we kind of just adapted as part of the IEEPA tariffs that I would say, oh, look, if I had, hindsight 2020, let's sit back and do it the right way and make sure we cross all our T's and dot all our I's. Well, those are the sorts of processes you need to be rolling out on a going forward basis. So whether that's contracting, data wrangling or better data management around your invoicing that shows you bearing the costs of that, tracking what's coming in your ACE portal with a little bit more diligence, right? There's probably a fair amount of reporting that needs to come online for some of our smaller clients, at least especially that have just, either not been importers of records or they have been, but it was just, they're busy out there trying to win work and make revenue, and sometimes processes are a little bit slower to follow along. Well, hey, now here's the time to hit the reset button and go, okay, let's put some best practices going forward into place.
So to that point, you and your team and our team here at Cherry Bekaert, what can we do to help our clients navigate, and what a lot of the things that you guys are implementing to support our clients and future clients?
Yeah, so Cherry Bekaert, right? I guess it's important to get clear on what we aren't, right? We're not a law firm, so we can't advise on tax. We can't advise on legal. We aren't global trade advisors, so we don't have this huge breadth of experience with all the trade laws in the U.S. and cross-border, et cetera. We are tax, accounting, assurance, CFO advisory, right? So we are able to help our clients sort of with the downstream effects of the tariff and trade world right now, meaning, are you paying tariffs? Are you seeking refunds? What does that look like from a make it up from an audit perspective, right? For example, if you're due a refund and you make a file, when do you actually have to report that and show that you're having this asset, so to speak, of a refund forthcoming along with the interest that's going to be calculated? How does that need to be reported for U.S. federal income tax purposes? Are there any state impacts, and could those vary by state? I think one area where there's a lot of opportunity is, especially for our lower middle market clients, is our CFO advisory work of, look, what are some of those best practices that we don't have in place that we should have in place in this new tariff, this pro-tariff landscape, also one that comes with the uncertainty of potential future refunds. And then we do have a great group called, I always call them just forensic accounting, but it's like forensic and dispute advisory. They have a deep history of working with external counsel and to support, various different types of complex analyses, especially around accounting and sort of financial data. If you find yourself not an importer of record, but you've borne the cost of these tariffs and you're seeking a refund and you're having to seek legal advice, and maybe you're moving towards a litigating posture and an arbitrating posture, and you need that kind of support, our forensic and dispute advisory practice is exactly the type of people that you should be talking to.
Gotcha. Well, that brings us to the end of today's conversation on tariffs in the industrial manufacturing world. Nelson, thanks again for joining me and walking us through what manufacturers should be thinking about right now. And to our listeners, thank you for spending time with us today. We'll continue to share updates and practical guidance on the tariff landscape. Look for more information on cbh.com/tariff updates as one word.
Thanks, Louise.
Thank you for listening to our podcast today. For more information, visit our website at cbh.com/manufacturing, where you can give feedback and connect with our professionals. If you enjoyed this podcast, please subscribe, leave a review wherever you listen to your podcasts, and share with your colleagues.